we may treat the petitioner as a witness, someone who knows about this particular deal. We have not made any accusations at all. I'm not sure why my learned friend had to make elaborate submissions on his client is not guilty of certain offense. She is not. This is not proceeds of crime. We have only there is a proceeding which under Section 50. All that I have to establish is that there is an investigation going on in respect of an ECIR, which is in respect of a FIR. Now we have to reassemble that. Is there a FIR? Yes, there is an FIR. Is there a predicate offense? Yes, there are a couple of them. There is 420, there is 471, there is Section 13 of the PC Act. Pursuant to that, is there a ECIR which is registered? Yes, we have registered ECIR. Is your investigation in relation to this? Yes, it is in relation to that. Have you summoned both of these petitioners in relation to this? Yes, I have. This is all that I have to establish when I have summoned a person. My learned friend's client need not feel that they are accused and that they have committed an offense punishable under Section 3. We want to know from them. We have to gather information from them. We may record, and if we do not find anything, we may not proceed at all. And Honorable Supreme Court says, if you find something, then you can proceed further. So therefore, what we have conducted, in the words of the Honorable Supreme Court, is like a civil inquiry. So in respect of a civil inquiry, initiation of Section 482 does not arise at all. Because my ECIR is not a document which is recognized under the code. It is only for administrative convenience I have given it a number. One more judgment directly on the point is, please have a look at the Madras High Court judgment at page 19. Para 9, page 20, para 9. It is to be borne in mind that ECIR is not registered under the Code of Criminal Procedure, and it is not akin to an FIR which is registered under Section 154 and sent to jurisdictional magistrate. The scope of an ECIR has been discussed with the division bench of this court in so-and-so, so-and-so. Then para 10. Thus, registration of an ECIR is an administrative act that is done by the officers of the Enforcement Directorate for initiation of an investigation under PML Act, which is a special statute, and therefore the same cannot be quashed in excess of the powers under Section 482 because registration of ECIR is not under the code. Then, my lord, one more judgment of the Honorable Punjab and Haryana High Court on similar lines. I will just read one para which your lordships will find at page 26. Para 7 at page 26. This court unhesitatingly concurs with the contentions made by the learned counsel for the respondent ED that ECIR is an internal administrative document of the ED. Consequently, in the considered opinion of this court, since the ECIR precedes the stage of criminal prosecution and proceeding, it thus falls outside the purview of the inherent jurisdiction conferred upon this court by Section 482 of the code. Therefore, the prayer of the petitioner for quashing of the ECIR under Section 482 of the code cannot be entertained. So these are the judgments, my lord, as far as the challenge to the ECIR is concerned. The second proposition, my lord, is that the summons to appear does not give rise to a cause of action, nor does it violate any legal right. That is my second proposition. For that, my lord, I have produced a few judgments. I will read one line from each one of them. Please take up the Supreme Court judgment in Kirit Srimankar case, beginning at page 146, where, my lord, their lordships refuse to interfere in respect of a summons. Page 146, right in the beginning, their lordships say, in the course of hearing of the writ petition, we find that the writ petition was premature. And then, my lord, next page, about 6 or 7 lines. The provocation, they say, in fact, when we peruse the averments contained in the writ petition, provocation for the petitioner to file the writ petition was the so-called search conducted on so-and-so date. It was further averred therein that the officer threatened the petitioner would be arrested, incarcerated in jail, and would face dire consequences. So-and-so. On that basis, writ petition came to file this court under 32. We therefore expressed it was highly premature for the petitioner to seek for extraordinary constitutional remedy under 32. Then, my lord, about 5 lines below. Inasmuch as it will be for the petitioner to work out his remedy as and when any appropriate positive action is taken. So, my lord, if I issue a warrant, then alone, my lord, it would constitute a positive action. Then, my lord, if your lordship would have a look at the Kerala High Court judgment, my lord, para 7 and 8 would be relevant at page 157. Para 7. To drive home the limited scope of interference at the investigation stage, learned ASG cited the decision in Commissioner of Customs, wherein Apex Court had cautioned that as far as possible, High Court should not interfere at the stage when the department had issued summons. In so and so, interference by the High Court into the interrogation of a person summoned under Section 40 of the FERA by fixing the time, Lord, that we can skip. Para 8. I find substantial force in the preliminary objection regarding maintainability raised by the learned ASG. Exhibit P11 summons is issued under Section 52 of the Act. A person issued the summons is bound to attend in person or through authorized agent as the officer issuing the summons directs, and is bound to state the truth upon any subject respecting which he is examined or makes statement, and to produce such documents as may be required. As held by the Apex Court in Kirit Srimankar, which I just read, no cause of action arises merely for reason of a person being summoned to state the truth or to make statements or to produce documents. And then, my lord, in Kuni Shetty judgment, the Honorable Supreme Court, my lord, para 14 is an interesting observation. In Kuni Shetty at page 162, their lordship said, my lord, a show cause notice.
Service law.
Paragilla. The principle, I am borrowing the principle. Allah, my lord, when I am borrowing a principle of a superior court, the law applied
Later ways.
We as counsel sometimes we tend to take seriously. Here, but the difference here is their lordship.
Here, 2006, page 9.
Allah, adralli, in a show cause notice, my lord, at least I make an allegation. When I issue a show cause notice, you have violated this law. You have done this. You are liable to be punished, prosecuted. And then I say, please give reasons. For that, the Honorable Supreme Court says there is no cause of action. Please look at this summons. I said, please come to my office and I want to record your statement. When I have not even made any allegation. So, therefore, my lord, there is no cause of action. In the page 165, Commissioner of Customs, first 2 lines, my lord, their lordships refuse. Interesting judgment is of Raghav Bail. Only 1 line in Raghav Bail, page 167. My lord, the Honorable Delhi High Court said,
Samankar is followed.
yes, and there, page 172, on the line, page 172, para 14. There is no violation of any fundamental right or any legal right of a petitioner warranting interference at the stage of summons. So, stage of summons, there is no violation.
That is the companion petition. The Senior Counsel C.V. Nageshwar appeared. Our summons matra.
Elrugu apply agutte. Both to both, my lord, even for Parvati, my lord, although she is accused number 2 in the predicate offense, as of now, we have not lodged a prosecution complaint at all. We have only issued a summons. And when we issue a summons, my lord, we need not disclose for what purpose we are in requesting the noticee to come. Only after investigation, we'll decide. If there is some material, we'll proceed. If there is no material, we proceed further with others. Please have a look at page 175, my lord, very recent judgment, December 2024. My lord,
Justice Arvind Kumar.
Justice Arvind Kumar. My lord, here also their lordships refuse to interfere in a summons. My lord,
discharge agogit.
Discharge agogit.
What the court of
yes. And then, my lord, the next proposition that I wanted to lay before lordship is that my learned friend Mr. Chauta made strenuous efforts to indicate that, and Mr. Nagesh as well, that their clients are not accused in the predicate offense. It is not necessary. Please have a look at Pauna Debur.
That's all.
Pauna Debur, my lord, 1 line in Pauna Debur, the last line in Pauna Debur.
I had dismissed it. Supreme Court has reversed it. My dismissal is reversed.
Yes. It is Pauna Debur, 211, page 211. Right. Page 211, para 31.1.
I had myself written, one need not be an accused.
Yes. I will read just
the predicate offense for summoning and conducting investigation.
To
Supreme Court reversed it, saying that if there is an allegation of conspiracy, only then it would survive. Otherwise, it's not.
But the principle that I want to read is 31.1. It is not necessary that a person against whom the offense under Section 3 is alleged must have been shown as an accused in the schedule of.
That is what I had written. Yes. She was not accused in the predicate offense at all.
Yes.
You will appear again.
And then, my lord, the next proposition that I want to lay is that I have already, my lord, covered it, which is that proceedings under Section 50 is, though called as an investigation, in the stricto sensu,
civil inquiry.
Stricto sensu is not a investigation for prosecution, it is a civil inquiry. So therefore, there is no difficulty for the notices to come and appear. In the end, my lord, I have furnished 2 judgments, which as a passing remark, my learned friend referred to the communication sent by the investigating agency to the complainant, saying that they have not found any material. But nevertheless, my lord, that does not have any bearing. But I anticipated that the other side would raise that issue, which is why I've already brought in two judgments. In a very recent judgment, the Division Bench of Honorable Madras High Court has held that if the investigating agency files a B report and if the magistrate accepts it, then ED can question it before a lordship under 482.
You just questioned it in one case.
Yes. And their lordships have referred to para 290, 190, alla? To para 290 of Vijay Madan Lal Chaudhary.
One, I think he has filed review ಹಾಕಿದ್ದೀರಾ ಅದರಲ್ಲಿ where B report ಆದ್ಮೇಲೆ.
So, my lord, I am as investigating agency, I mean, as an authority under the PMLA, I am interested in the outcome of these proceedings. I am interested in the issues. So therefore, my lord, in this case, merely because the investigating agency has said that there is no material, unless the court accepts it, my lord, I have got a legal basis to continue. So therefore, my lord, my continuation. Okay. My lord, would your lordship please have a look at page 238 in my compilation?
I am
Page
there-
238.
I am there on.
Lord,
66(2) ಬಗ್ಗೆ ಅದೆಲ್ಲ ಇರೋದು.
how's the,
Yes.
the 60, which is why, my lord, may I read, my lord, because quite assertive submissions were made in respect of a letter that I have produced at annexure R1. Please have a look at 66(2).
No, it is here.
No,
Purport
Allah,
of that
66(2) ಓದ್ಬಿಡ್ತೀನಿ, but I am surprised.
contemporaneously sending
I do not
information.
understand how, my lord, my learned friend has a grievance if I issue a letter. My lord, please have a look at the scope of 66(2). 66(2) says, if the director or other authority specified under subsection 1 is of the opinion on the basis of information or material in his possession that the provisions of any other law for the time being, my lord, it can be a tax law as well.
This is no problem at all.
No, but my learned friend had a certain grievance against it, that how I can write. I can write. In the course of investigation, if something has come to my notice, why should I not bring it to the notice of the local enforcement authority?
Submitted.
I thought that was his.
What they're trying to write is about the investigation to the predicate offense, that they can't.
No, that is.
No, I am giving
66(2)
information. that
ಅಲ್ಲಿ
is posted.
You
No,
are informing other authorities that these are
No,
these are the
let me read Athkodi.
findings of
Annexure R1.
investigation.
No, let me read annexure R1. I don't find anything contrary to law. to
So
that.
that's all right.
And
that's-
anyway, my lord, 66(2), it is for that local enforcement authority either to accept it or not.
That's
No.
good. It is not that
No, no, let
you
me
send
explain.
it and-
My learned friend, no, let me explain. My lord, I have referred to, my lord, my learned friend had a problem with illegal allotment, illegal denotification. All these have led to generation of proceeds of crime. Somebody would denotify and get it allotted to somebody, gets money. We have materials for that.
for
Why
others,
should I not bring it to the notice?
you bring it to the notice.
Yes.
You are bringing
No,
it
what
to
is
the
what is the
notice.
difficulty of these two petitioners if I bring it?
No,
to the
no,
notice?
predicate offense. These whoever is here, ಅವ್ರದ್ದು proceeds of crime ಅಲ್ಲ ಅದು.
No, for each one of them, there is a different proceeds of crime. As far as Mr. Chauta's clients are concerned, the
Chauta's
proceeds of
client
crime
is
quite clearly is 14.
14 allotments.
Yes. As far as Mr. Suresh is concerned, my lord, we have, during the course of the investigation, we have discovered that several approvals and directions were given from his office to the office of the MODA. So we have
After he assumed office.
my lord, yes, after he assumed office, and it continues. He continues in office. So we want to get some information from you. There shouldn't be no difficulty. It is only for the purpose of gathering information. It is to find out whether there is any, my lord, as someone.
Then what do you say about the coordinate bench? That also was for that purpose only.
My lord, the coordinate bench, my lord, my respectful submission is, my lord, that the certain observations in that judgment are per incuriam, my lord, it is under challenge. My lord, his
Per
lordship,
incuriam to what?
per incuriam to the law declared by the Honorable Supreme Court. It's a per incuriam, I mean, to opposed to para 290, para 431.
Jay Madan Lal.
Viday Madalach. Viday Madalach. My lord, that para 54, 55, 6 of that judgment requires me to record a prima facie case, even to summon, which is not the law.
Which coordinate bench is?
Yes. It says you should have a prima facie case to even to summon. And I furnish judgments to point out. My lord, there, my lord, the main ground on which his lordship was inclined to accept is that upon going through the reasons to believe, which we gave in a sealed envelope, His Lordship felt that it is not sufficient in that case. In that case, against that petitioner, as against that petitioner, His Lordship felt it is not sufficient. That is not an argument which is raised in this case. That is not an argument. So therefore, that is the main issue. The main issue was whether the reasons recorded in the reasons to believe is sufficient. And the answer to that, it is not sufficient. It says it does not meet. So therefore, my lord, that judgment would not be of much help. Therefore, my lord, to summarize my submissions, my lord, there is a predicate offense, and pursuant to that, proceeds of crime have been generated, and we have registered a ECR. In connection to the ECR, we have merely summoned both the petitioners, and our inquiry is of civil in nature. We want them to produce certain documents. We want them to disclose their property and account details, as also their relatives, because our past experience has shown that proceeds of crime is generally purchased in the names of relatives. So therefore, we want to investigate that. And this investigation is permissible in law. I have followed all the safeguards which are predicated under 17 as well as 50. And the challenge.
Now, if it does not cooperate, what do you do?
Well, they will.
Civil inquiry.
There is a law, my lord, we will follow it. My lord, I do not want to make a submission. My lord, there is one issue, my lord, which my learned friend, my lord, my learned friend mentioned about he referred to the submissions made by the learned Solicitor General and the additional Solicitor General. The Supreme Court has repeatedly said, do not read judgment like a statute. But my learned friend went beyond that. He is reading the submissions made by the law officers as a statute. One cannot read portions of the submissions to interpret as a law. We have to understand for what purpose those submissions were made. So therefore, when judgments cannot be understood as statute, the submissions made by law officers cannot be treated as statute. We have Section 3 that has been interpreted by the Honorable Supreme Court. That should be.
No. His submission was, what is the intention of the, what is the mind of the union also is what is.
No, one cannot take out piecemeal submissions to it. One has to understand the entire judgment and then to it. So, my lord, piecemeal reading does not give the entire intention of what the Union of India is. So therefore, my lord, my respectful submission is that it is not permissible to read a portion of it and say, this is what the government intended. My lord, our submissions have been considered by the Honorable Supreme Court and interpreted. It is the interpretation of the Supreme Court which matters. I am grateful.
Yes. Fantastic. Yes.
2-3 aspects of it.
Rarely some great submissions. Yes. Yes.
I'm sorry. 65. Well, section 65 makes the provisions of CRPC applicable. No doubt about that. When my learned friend is saying that you are not an accused, I have never labeled you as an accused, instead of issuing me a notice under section 50, as my lord has pointed out, non-compliance with the entire arrest, all that. You ought to have issued me a notice under section 161 CRPC.
Statement recording.
I am not a police. Supreme Court says I am not police.
Sorry. But section 65 says the provisions of CRPC are made applicable. Issue me a notice. Why a notice under section 50? ಇನ್ನೊಂದು ಹೇಳಿದ್ರು ಅವರು 482 ಇನ್ವೋಕ್ ಮಾಡೋಕ್ಕಾಗಲ್ಲ ಅಂತ ಹೇಳ್ತೀರಾ? To secure the ends of justice, to prevent the abuse of process of law.
Miscarriage of justice.
Miscarriage of justice.
So long
We can
as
suddenly
it's
invoke the
seen
jurisdiction of the court under section
Mike.
482 or even under article 226 and 227 of the Constitution.
So long as it's seen that the basic ingredients to constitute an offense is missing, then to say, no, allow us to have a roving inquiry, we will fish and we will see what we can get out of it. That is totally impermissible, my lords.
Yes,
If
sir. They will fish to find something fishy.
Fishy and then go. That can't be done. Now, if at all, my lords, they're not in a position to show that there was an activity or a process in furtherance of this proceeds of crime, where lies a power or jurisdiction to register an ECIR and have an inquiry? Very basic. And then, my lord,